if the regular channels of being prosecuted are dropped, and then you have a vindicated uh, command that just wants you out because for personal reasons, now they're able to use this as their way to punish you for something that they most likely could not convict you of. That's what I'm
Absolutely.
hearing.
Absolutely. Not just most likely could not, they likely could not have. Because if the Office of the Special Trial Counsel, again, they have a good faith belief that they can obtain and sustain a conviction through admissible and relevant evidence, then they're going to take that case to trial. Their OSTC are typically the senior prosecutors in the military who are given wide discretion to prosecute sexual offense cases. They are not told to defer cases. When OSTC defers cases, there's a lot of paperwork that has to be generated for them to cover their own ass as to why they're deferring a case. So
Mhm,
deferrals
mhm.
aren't done lightly. We see, I'm still replete with sexual assault prosecutions. I'm just seeing more serious ones now. What I'm not seeing is the baseless ones. Those now, where they're clearly baseless, you have a vindictive command who didn't like that decision, is sending a Marine or a soldier. I'm just not seeing this as much in the Air Force and the Navy, thankfully. It's probably coming. I'm just not seeing it. I mean, I'm seeing it across the board. It's pervasive in the Marine Corps, a little bit less so in the Army. So I'm just kind of sticking on those two. And I'm hoping it doesn't trickle down to the other services. But now they're being notified that they have to defend themselves against a sexual assault allegation at an administrative separation board where you have very limited due process rights, where you don't have the ability to subpoena witnesses, to subpoena evidence, to file motions, where hearsay is allowed, double hearsay is allowed, where sworn statements are admitted against you. So let's say, and typically the alleged victims never testify at these. They'll give a sworn, which is curated by NCIS or CID. They don't want to testify because they don't want to be cross-examined. We talked about benefits earlier. A lot of people, unfortunately, scam the system and make sexual assault allegations to have sexual assault trauma in their record because under the VA, you can fairly easily rate 70, 80, 100% VA if you have some type of sexual assault trauma. There has to be some evidence of it. So if you make a sexual assault allegation and now you're seeing a therapist, there's this NCIS investigation into it. And then you say, well, I don't want to prosecute anymore. I just don't want to go through the process because number one, you know, it's bullshit and you are using this to make money. And trust me, this happens. I had a case recently we talked about later where I've proved this happened. And now this alleged victim is going to get their $4,000 a month payday for the rest of their life because they have MTRS, military rape trauma syndrome, which is a rebuttable presumption under the VA, which should change, but that's the way it is. Now the command is sending this Marine to an administrative separation board, and I'm not even able to cross-examine the alleged victim. Their one-sided statement comes into evidence, and I'm not even allowed to cross-examine them, and I don't have the ability to subpoena witnesses. And the standard isn't beyond a reasonable doubt. The standard is preponderance of the evidence, which is 51% more likely.
That brings up now, obviously, as a Marine veteran, you're bringing back memories of how things operate, right? It's been years since I've been in, and now, so I'm putting myself in this Marine situation. So this would scare the hell out of me.
It
It would be
should.
like, okay, they're not prosecuting me. They're doing this. How in the hell do I defend against this? Especially when all these things that you're talking about, like the witnesses don't have to testify. It's based upon somebody's decision. It's not going to be in front of a jury. It's all these things. It's going
And
to be based upon.
hearsay is admissible. Think about that. Hearsay is admissible. And double hearsay, because so an agent can come in and NCIS agent can come in and testify as to what they were told by a witness or told by an alleged victim, and I have to then cross-examine the NCIS agent about what someone told them. And it's staggering that this is allowed. It was never designed for this. And I've had cases where case will go to a BOI and the government calls no witnesses. What they'll do is they'll take the NCIS investigation, just admit the evidence and not call any witnesses, and then call the chain of command in to say, "Hey, this Marine's a shitbag." No, I've had it where a chain of command will come in and say, "I'm a lieutenant colonel in the Marine Corps. I've been in for 21 years. Based on my observation of this Marine and my experience, I believe this Marine committed this offense. I believe they're guilty of it for all of these reasons. And I make a strong recommendation to the board to discharge him based on opinion." And so the cross-examination's fun, right? But it's wild what's admissible on these boards, and you have very little due process rights. And again, the standard is 51%. And then
So,
and
so
then
how do you the
go ahead,
oh, sorry.
go ahead.
I was just gonna say, I mean, you're continuing to scare me. How on earth do you defend yourself against this?
Well,
I mean, let's get to the meat of the matter. That's
yeah,
really
I
what we're
mean, before we go, I'll drop one more thing before we even get to that to scare the hell out of you even more. Now you're going to get detailed a military counsel to represent you. Once you have notified of an administrative separation board, you rate counsel, but you don't rate the best counsel. And so what happens is, and I mean that with all seriousness. So in the military, you have to be what's called certified, qualified, and certified under 27 Bravo, which means that you have to have a certain amount of court martials and a certain amount of experience to actually practice in court. If you're not, you have to be under the supervision of a more experienced attorney. Think about this as you have a teen driver. And just my son just turned is no longer a teen driver, but was. And when he had a driver's license, he could only drive in the car with an adult with him. Okay. And I think that's like that for a lot of states. And so as a new attorney, you can only be in court with the supervision of a supervisory attorney until you're qualified and certified under 27 Bravo of the UCMJ. Well, you don't need to be qualified. You don't need to be certified to do an ad step board. And so what they do is to get get new defense attorneys, to get them the reps, to get them to the point where they can go to court. They assign them ad set boards. And so you're typically going to get assigned, not always, and some jurisdictions are better about this, but typically you're going to get a JG, a 1LT, or you're basically going to get an O2 or a very new captain who is brand new to the game. Because if they're not doing ad set boards. There are some circumstances where you have good leadership and the senior defense counsel will detail highly qualified attorneys or more qualified attorneys to represent you. But for the most part, you're getting the brand new JAG who's brand new to defense and is trying to get certified to do court martials by doing ad set boards. And oftentimes they're doing 5, 10, 15 ad set boards. So not always, but more times than not, you're getting the newest defense counsel in that region who is just trying to get the reps to go into a court martial. So not only do you have diminished rights, but you usually have a extraordinarily junior attorney who is doing this to build his ability up. Not always, or his or her ability, but more times than not, that's what we see.